Category D.
24 cars.
Yes, 24, my lord.
6%.
Fourth is, my lord, 4 cars given 1%, my lord.
4 cars.
Yes, my lord. Now, my lord, what happens is, my lord, earlier, who were getting in the entirety in the 15, my lord, whether they could compete with it, did not do it, we are not concerned, my lord. But 15, I suppose I was eligible for the 15%, my lord. Today, by virtue of being classified into class D, I get only 1%, my lord. That is 24 cars will get 1%, my lord.
So 24 cars, you said 6%.
6%, my lord. But 50 from 24, my lord, 4 cars, 1%, my lord. 12 cars, 1%.
Earlier, everybody was competing for the entirety of the 50%.
Entirely. Earlier, I could compete for the entire 15%, my lord. So therefore, my lord, in the light of that, this judgment was delivered. That's why I read the questions, my lord. But what were the questions before this honorable court? No, my lord, what is actually happening is they have tinkered with 341, my lord, second portion. You have varied the list.
That is included, not excluded.
No, to say, my lord, that we are still there. No, but you have varied the list, my lord.
Still the same. They are all being given maybe different percentages.
No, my lord, but today, my lord, what happens is, that's why I said, my lord, 12 people, 12 cars or 4 cars.
There could be other reasons also. What is their population? What is their population ratio? What is their representation in the services? That is an exercise to be undertaken by the government.
My lord, that the earlier advocates have shown, my lord, that there is a route to it. If you find somebody has gone above the threshold, my lord, delete them. If you want to bring in new people,
And do it. They can't do that. That is done by the central government.
list, my lord.
But they are trying to maintain a balance between all the classes.
It's a different matter that for arriving at such a finding, there was no empirical data.
There was nothing.
So that will be going to the merits of the matter.
So therefore,
Whether it is permissible or not, that's a question.
That's a different question.
whether as a matter of principle, Chennai is right or wrong, we are deciding. But the Act may still not pass muster in the absence of verifiable data in regard to underrepresentation, etc.
My lord, this is 2005. Then 7, my lord. Initially, my lord, the ordinance was challenged, which was upheld, which was struck down. Then the state came here. Then the legislation came.
So as far as the other side, anybody dealing with Andhra Pradesh on this side or?
No, nobody. Mr. Luthra made a statement that we will abide by the judgment, my lord, as if they have a choice.
Dr. Muralidhar appeared for Andhra Pradesh, and they said
they will abide by it, my lord. As
Mr.
if they
Luthra
have a
appeared
choice.
for
Whatever your lordship say will be.
Chennai set aside the Act. All right, so Chennai held the Act to be unconstitutional.
Right, my lord.
Now, if we in a separate proceeding, if we come to the conclusion that the judgment in Chennai does not lay down the correct principle, that will not per se result in the validation of the Act. Because
Your lordship may clarify that, my lord.
Because one second, we do not have any appeal pertaining to Andhra Pradesh before us, right?
There is a writ now, my lord, filed by some of the people who get benefit by this, my lord. For I think Mr. Venugopal argued.
My lord, I appear for the state of Andhra Pradesh. My lord, the Chief Justice has rightly observed, there is nothing by way of an Andhra Pradesh review pending as far as this reference is concerned. So,
How is Andhra Pradesh before us? How are the people from Andhra Pradesh? They are interveners or what is
yes,
happening?
no, my lord. Actually, by way of a PIL, that is in item 701.22.
Yes, Mr. Krishnan?
My lord, in item 701.22, a writ petition has been filed arraying all the states of the country asking for overruling of Chennai. That is the only incidental basis on which Andhra Pradesh is technically before my lords.
In a collateral proceeding, even if we overrule Chennai,
That's right.
that will have no impact on the act which has been...
Yes, that act has been struck down, my lord, and since the act has been struck down in our own case, we have not reenacted anything in defiance of this honorable court's
It's
judgment.
open for the state if they want to come with a fresh enactment or not.
Yes.
And only after a fresh enactment comes in the eventuality.
And that will
then
be
you have
sub-
something.
No, Lord.
and that will be subject to a challenge.
Why I am not going that far is, my lord, I don't want to come back again saying, my lord, that in view of a lordship, they have reenacted, my lord. Today, my lord, this was actually a political move, my lord.
But Mr. Rao, we will not comment on the facts of the Andhra Pradesh Act in this proceeding, for the reason that whatever we do is not going to affect the mandamus or the certiorari which was issued by this court, or the declaration which was issued by this court in Chennai, which was their inter partes. What we will decide here, the only live case which is before us is
This is
the Punjab case.
But
Furthermore,
what happens
if
is,
I may
what
just
happens
say
is,
this,
Lord,
my
the
lord.
apprehension is, my lord, you see, a series of litigations would start now. The enactments would come, my lord, because this move in the state was only for a political purpose.
Just वो एक मिनट बंद कर दो.
Yes, it's not only money, it's not only lawyers' money.
The petitioner, who is the lead petition, was the lead petitioner in Andhra Pradesh, and then matter filed here, it was registered on the name of EC Chinmay. I was the second or third petitioner there, separate petition, that my name is there. I am there, Milad, from the Andhra Pradesh side to represent the scheduled caste. And Milad, here I will just deliver upon Milad, whether the backward classes, that term, and the 16th class 4 includes scheduled caste or not. That is the only preview of my argument.
So, Mr. Rao, what else now?
Well, the problems which were raised by the court, my lord, as to what happens within the group who are not then. Lord Justice Sinha has given certain remedies, my lord, which are at page, my lord, 815, my lord. Now, apart from that, my lord, a solution can be found out as to how, my lord, these things, reservations have to be worked out, my lord. Yes, my lord, we are seeing, my lord, because of the ground situation, that some people are garnering, my lord, some people are not getting it. They are not getting it because of the socio-political situation, that they are not allowed in the village, and the census is taken only in the village, my lord. This has to be restricted, my lord. Maybe one suggestion is, my lord. Suggestion I'm giving as an officer of the court, my lord, not this thing. My lord, suppose, my lord, what happens today is, my lord, a person is getting a reservation. Well, suppose a person is getting reservation, my lord. He gets reservation at all stages, my lord. For instance, at the admission, at the time of school, at the time of college. For instance, he goes into a medical this thing, my lord, he gets the reservation. Then in the job, he gets the reservation. This has to be looked into by the government, my lord, how as to see, my lord, that how it reaches to the bottom. But it can't be, my lord, that they will tinker with the list, my lord.
That
They
is
are
the
not
point.
tinkering with the list.
No, tinkering with the list
No,
as such.
they have varied the list, my lord.
No.
From 15, I have got one, my lord.
It's not a varying the list. Where is it provided in the list?
The list never gives you
The
50%.
list never gives you a percentage that you will be
List
getting
never gave,
10% or somebody is
But
getting.
today,
It has been worked out
today,
by Mr.
today, my lord, the constitution, in the constitution it is provided that SC/ST would get the, how much they will get, my lord. That has been varied, my lord.
No,
Nowhere it is provided in the constitution.
Where does the constitution say that you'll get 15.5% reservation? Show us the provision.
Adequate representation.
Huh?
Adequate representation.
Adequate representation.
But I am, today, my lord, I have been deprived of it.
But therefore,
My percentage has gone down, my lord.
your argument is on the challenge to the act per se. Not on, that doesn't turn on Chinaya.
Act per se, my lord.
That act is no more in existence now. So
Act is
you
not,
have given some new
but
act
since we were parties in the original, my lord, and that judgment is under reconsideration.
Whatever happens to the judgment, that can't result in a revival of the act.
That's it.
You are answering.
All right, thank you, Mr. Ram.
Can I
Mr.
give
Hegde?
a small written submission, my lord?
Yes,
Lord,
yes,
I
sir.
also appear in one of the IAs, my lord, filed by a police officer. That IA number is, my lord, 120962 of 2020. I'll give it to the court master, my lord,
Okay.
the matters in which I am appearing.
Yes, Mr. Hegde.
Not the others, I am not repeating, my lord, I wanted to shoot him.
There is nothing to argue.
What is the point that you want to make?
Just a bit. I do realize that we are at the end of a long and weary hearing. So therefore, I will not bore your lordships. I'll go on the sound principle that if you don't make a point, you stop boring. Now, here, my lords, it's like this. The point that Dr. Chauhan finally came to was what is the distinction that marks a scheduled caste? And the answer given was untouchability. I want to bring to your lordship's notice a judgment in suicide, which sets it out succinctly and our constitutional history. It is 1985 Supplement SCC, page 590, my lords, paragraph 7 thereof. It has been uploaded. Please, my lords. Para 7. Now, it cannot be disputed that this caste system is a feature of the Hindu social structure. It's a social phenomenon peculiar to Hindu society. The division of the Hindu social order by reference at one time to professional or vocational occupation was molded into a structural hierarchy which over centuries crystallized into a stratification where the place of the individual was determined by birth. My lords, after all that preliminary thing, my lords, let me just come to the second part of J.H. Hutton, the last line of 594. J.H. Hutton, a census commissioner, framed a list of the depressed classes systematically, and that list was made the basis of an order promulgated by the British government of India, called the Government Scheduled Castes Order. The Constitution Scheduled Castes Order is substantial.
That we saw yesterday, actually.
Please, my lords. Now, during the framing of the Constitution, the Constituent Assembly recognized that scheduled castes were a backward section of the Hindu community who were handicapped by the practice of untouchability. And this evil practice of untouchability was not recognized by any other religion. And the question of any scheduled caste belonging to a religion other than Hinduism therefore did not arise. The Sikhs, however, demanded that some of their backward sections, the Mazhabis, the Ramdasyas, the Kabirpanthis, and the Sikligars should be included in the list of scheduled castes. This demand was accepted on the fact that these sects were originally scheduled caste Hindus who had only recently converted to the Sikh faith and had the same disabilities as the Hindu scheduled caste. The depressed classes within the fold of Hindu society were therefore made the subject of the original Constitution Scheduled Castes Order, subsequently was also amended. Now, my lords, the point is this. The difference between the three categories. Scheduled castes necessarily means that everybody has suffered the taint of untouchability. How untouchable? That's a different thing. There were some people who were merely not seeable. There were some people who were touchable. There were some people whose money could be touched. Now, all of those were put into one class by the Constitution of India, in the constitutional order, in the presidential order. And that is why they were called scheduled castes. Now, the castes may be individual.
From where do you find this?
My lady,
Except this.
I just read this. I read this
That is
passage.
in the judgment. but-
In the judgment, and my lords, there is supporting material also that can be placed. But, there are several judgments of this court which go on the footing that what distinguishes the scheduled castes from the other backward castes is the taint of untouchability. Once there is the taint of untouchability, how untouchable were you? The Constitution and the Constitution makers at that point of time decided not to go into that question. They formed one homogeneous class. And that homogeneous class they said that you could possibly include or exclude through parliamentary enactment, but in no other manner. So therefore, a court could not add or subtract from it. The executive could not add or subtract, nor can the state legislature tinker with it in any manner whatsoever. That, my lords, is the basis of Chinnaya. And the passages at paragraph 26
That we have seen.
onwards, that was the basis. Now the basis that 341(2) stood as a barrier to anybody else tinkering is supported not only by the speech of Dr. Ambedkar, but it is also supported by another constitution bench, which is a 5-judge bench, which is Bir Singh. Devinder Pal refers to Bir Singh but does not appreciate Bir Singh, my lords. Bir Singh, just get it on the board, 2018 10 SCC. 8. Please, my lords. Yes. If your lordship first sees the question which was posed, the question in Bir Singh.
Page.
Yes. I'm sorry.
Citation page. 312.
312, but my lords, to cut short time, the question in Bir Singh was basically whether if somebody was a scheduled caste in one state, but then migrated to a union territory, would he have the scheduled caste status? And in that context, my lords, if I can place paragraph 36 onwards, where after noticing these various questions, please, my lords.
I think Justice Bhanumati dissented, right there?
No, there's a slight dissent, but not on in this. Please.
Para 36.
Para 36. The upshot of the aforesaid discussion would lead us to the conclusion that the presidential orders issued under Article 341 in regard to scheduled castes and under Article 342 in regard to scheduled tribes cannot be varied or altered by any authority, including the court. It is Parliament alone which has...
Also, more than settled.
Yes.
Not tinkering is more than settled right from action committee.
Please, my lords. Now, if...
Where is the,
please.
Is the state tinkering with the list? Are they
Yes.
reviewing any,
please, my lord.
entry or adding any
Please,
entry?
my lords. If... I'm sorry, my lords.
It is not under control. Somebody else is managing there. You are trying to go scroll down and scroll up.
Yes, my lords. So 36 to 38.
You are under control, no problem.
It goes on the same footing. Now
the quarrel on that proposition that no tinkering is
yes.
permissible by any authority in the court.
Now let's take this further. If I continue to be a scheduled caste in the list in name only, but no benefits are conferred on me, while benefits are conferred on another scheduled caste in that same list, I am effectively rendered with the stigma of a scheduled caste, but no consequent benefits. That can also happen. In a sense, it's a reverse pran pratishtha. That my caste remains on the list, And yes, you are a Jatav or but for this year we are taking only Valmikis. Or to use the Maharashtra example, if we say that no Mahars will be taken.
Right, but therefore, this is a challenge not to subgrouping in principle, but the manner in which the subgrouping has been carried out.
It's also,
For instance, that's when I give them the example. Suppose Punjab had said we are taking only the Balmikis and not the Mazhabis, or only the Mazhabis and not the Balmikis. Would that not be amenable to challenge? Possibly, yes.
that would be tinkering, my lords, in my respectful
Right,
submission.
consider
In
that.
my respectful
Now,
submission.
Mr.
And
Hegde,
also-
we've heard that
No,
for
no,
the.
just 1 minute, just 1
There's nothing
minute.
new now.
Let me give your lordships an example.
Seems the common
No,
refrain now.
Let me just.
We were keen to now put some points.
you
to
had-
the
Yes,
other side
I know
joint
that.
there.
So
You had assured us that you will not repeat anything, but you are repeating the same thing right
my
from
lords.
Mr. Swarup and everybody else.
Please, my lords, one last.
Yes, tell us.
One last reason why your lordships should not leave it to the states. Your lordships noticed Dr. Ambedkar's thing, that political ones.
Political.
Now, my lords, India is not comprised only of big states like Punjab, Andhra Pradesh, or anything. There are a lot of small states. And a political decision there. For instance, your lordships have seen the recent violence in Manipur. Now, if only one particular community is knocked out, if you leave the power to the hands of individual states without any reference back to the center, my lords, then what we are asking for is effectively a balkanization of this list. You would be setting up one, as you are, borrow the Chief Justice's language, backward against backward.
All right, thank you. We got that. Thank you, Mr. Now, we're
great.
going to, yes, Mr. Meshram, we'll give you 2 minutes, please. Yes, what is the point just formulated, Mr. Meshram?
That 16 class 4, which talks about backward class of citizens, Millard, that does not include scheduled caste, Millard. I am aware about the Indira Sawani judgment.
What is your submission?
Yes, Millard. When the backward classes was included, backward word was included in Article 16. Millard. Before that, the scheduled caste reservation was already settled in the Constituent Assembly. And therefore, the
You're saying
reservation.
that by backward classes doesn't include scheduled caste?
No, sir. No, Millard. Therefore, I will take Millards to the Constituent Assembly debates, Millard, and the TCUR's documents, Millard. And this argument has never been taken.
But that has been dealt with in.
Yes,
there are
Millard, yes,
It's
yes.
a larger bench.
No, Millard,
Yeah, bound.
this is how nobody nowhere in the history of the Supreme Court, Millard, that argument was built upon by this court, Millard. And therefore, Millard, straight away I'll take to this court on the minority subcommittee's report, Millard, of 1947, my volume 4D, Millard, compilation, filed volume 4D, Millard.
For ABC, B.
4D for Delhi, Millard.
We don't have. D तो है नहीं, there is no D.
For B, you said, no?
We have sent the email. Yesterday we have sent the email.
You have to send the email to the nodal council because then only nodal council are authorized to add to our
The
report.
nodal councils, Millard. But I'll just read it out to Millard for that purpose. I'll read it out to the Millard. That the subcommittee then, this is from the B. Shiva Rao, Millard. This is the minority subcommittee report. The subcommittee then examined the demand put forward by representatives of Anglo-Indian community, but thought it advisable that the question of both minorities yes, Millard. Reservation in services. The subcommittee voted on the general proposition that there shall be reservation in the public services for the different communities mentioned in group A, B, and C of paragraph 3, clause 3, Milord. Milord, paragraph 3, clause 3 pertains to Anglo-Indians, that is group A. Group A, Anglo-Indian, Parsis, Plains tribesmen in Assam. Milord. Group B pertains to Indian Christians and Sikhs. And population, and group C, Milord, for the Muslims and scheduled caste. So now, Milord, they were considering the reservation for these three groups, Milord, and they have held, it was agreed that the provisions, if any, regarding reservation, word is most important, Milord, regarding reservation should appear in a schedule up to the Commission Constitution Act, and should have the force of directive of government policy. The decisions were as follows. 1. Agreed by a majority of votes 16-1 that there shall be reservation in services for the scheduled caste. This is Article 296, Milord, corresponding to Article 335 of the Constitution present, Milord. Then agreed by a majority of votes 9-7 that there shall be reservation in the services for Muslims, and so on and so forth, Milord. And then they have specifically considered one more aspect, Milord, that the subcommittee then considered the question as to whether seats should be reserved even for posts for which computation examinations are held. The decisions were as follows. A. Agreed by a majority of votes 11-6 that there shall be reservation for scheduled caste in services to which recruitment was made by competitive examination. This is Article 296, Milord, corresponding to 335. Now, Milord, that 296 was differently worded during that time because the reservation was granted based upon the minorities, Milord. And that article, Milord, was worded as.
What is the submission that you are?
Submission is that the 16 class 4 does not apply to the scheduled caste and their reservation comes from 335. Because altogether this aspect was
335.
335.
335 doesn't speak about reservation. It only says that
Yes, Milord.
names of the scheduled caste should be
Just
taken.
into the efficiency of administration. And you know, the danger